Ready, start. He thus submitted that it is the case of the prosecution that pursuant to this the appellant confessed to the crime and produced the two gold bangles from his pocket at the hospital. It appears to be unreasonable that the appellant would be carrying the bangles with him at these odd hours, that is 4 am, and that too 2 days after the incident. Therefore, planting of the gold bangles upon the appellant cannot be ruled out, casting serious doubt upon the alleged recovery. The unfortunate incident had taken place where an old lady of 85 years was not only robbed but was raped and murdered brutally. But the question would be as to whether the appellant is the person who has committed the offense. The medical evidence would only point to the offense having been committed, but unfortunately, prosecution has not been able to connect the appellant to the offense on the basis of medical evidence except to the extent that the appellant was found to be potent and thus capable of committing the said offense. But that would not suffice, nor would it connect or associate him to the offense. No hair or skin sample has been collected from the site which would connect the appellant in any manner with the place of the incident or the offense. Merely because the medical evidence proves the unfortunate loss of life would not be enough to convict a person since he happened to be in the vicinity. In the absence of any forensic evidence, when there is no eyewitness and the case is of circumstantial evidence, benefit would go to the accused. As it is apparent from the statement of the investigating officer within bracket PW16 bracket close, a sniffer dog, a fingerprint expert, and a photographer had visited the place of occurrence with him, and that too in quick succession, rather simultaneously on the visit of the investigating officer at 7:30 am on 19/12/2016. Nothing has come on record which would indicate any fingerprint of the appellant having been found at the place of occurrence. The sniffer dog has also not been able to guide them to the house where the appellant was residing. It may not be out of the way to mention here that the place where the appellant was staying with PW6 was not far off from the place of incident, and that is one of the reasons which has been taken by the prosecution as a possible factor for the commission of the offense by the appellant. The prosecution evidence raises doubts regarding the involvement of the accused. In the judgment of this court in Kaliram versus State of Himachal Pradesh, it has been held that in cases wherein the guilt of the accused is sought to be established by circumstantial evidence, if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted.